indicated that you wish to represent yourself on this matter?
Yes.
This is the moment where the entire trajectory of the case is set. The defendant chooses to represent himself, and that single decision immediately raises the stakes. In felony cases, self-representation is not just uncommon, it's extremely dangerous if the person lacks deep legal knowledge. What you're about to witness is not just a courtroom exchange, it's a collision between confidence and procedure. The defendant believes he can navigate this system alone. The court already knows how this usually ends. The judge is about to issue a series of warnings, and these are not optional advisories. These are legal safeguards, put on record to make sure the defendant cannot later claim he didn't understand the risks. And here's what makes this more intense. The charge itself carries real consequences: years of incarceration, financial penalties, hours, and loss of driving privileges. This is not a minor issue. This is a life-impacting situation. So ask yourself this: what drives someone to reject legal representation in a case like this? Is it strategy, or a fundamental misunderstanding of how serious this situation actually is? Because from this point forward, every word he says, every motion he makes, every mistake falls entirely on him.
All right, you understand at your arraignment you were given the charges that were have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding,
Fleeing and eluding third degree.
third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
I do, but I have some questions.
As soon as I get through this, you have indicated that you wish to represent yourself. I have to advise you that there are some dangers in you representing yourself. You understand that, sir?
I do comprehend.
And you understand that if you proceed to represent yourself, that the court is not going to assist you to understand the procedures or anything regarding the court proceeding, that you will be responsible for that, and I will be holding you to the same standard that I would be holding the attorneys in the room in terms of even ruling on evidence or anything along those lines in regard to the procedure and the process. You understand that, sir?
Correct, I comprehend.
All right. You also, so I will ask you again, do you still continue to wish to represent yourself in this matter?
Yes, I will be defending myself.
You understand also, sir, that should you change your mind and could not afford to hire an attorney and wish to be represented by an attorney, the court would consider making sure that you are afforded counsel. You understand that?
I comprehend.
How do you wish to proceed on this matter, sir?
First, I want to like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of a personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing, and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department.
Now we've moved roughly 2 minutes forward, and you can already see the pattern forming. The defendant launches into a dense, technical-sounding argument. Probable cause, jurisdiction, trusts, constitutional rights. But there's a major issue: structure. In real legal arguments, clarity is everything. You build a claim, support it with precedent, and tie it directly to the facts of the case. What we're hearing instead is a stream of loosely connected legal terms. And this is where things get critical. Arguments about trust property, of court property, fictitious entities, or claiming there's no crime without an injured party. These are not recognized defenses in criminal law the way he's presenting them. From the court's perspective, this isn't just incorrect, it's irrelevant to the current stage of proceedings. And here's the deeper issue. He's trying to fight the case on theories instead of procedure. Courts don't operate on belief systems. They operate on rules, timelines, and evidence. So now the tension builds, because the judge is about to respond, and when she does, it's not going to validate this approach. It's going to shut it down.
Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser. With the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
Done. Finished?
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance certificate of security to settle and offset the charges.
Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
Another 2 minutes pass, and the judge now brings the conversation back to reality. Procedure. This is a critical correction. The defendant is arguing probable cause right now, but the court hasn't even reached the stage where probable cause is formally evaluated. That happens during the preliminary examination. So legally speaking, his motion is premature. And that word, premature, is important. It doesn't just mean wrong. It means wrong timing. In law, timing can make or break an argument. Even a valid argument raised at the wrong stage gets denied. And that's exactly what's happening here. The judge isn't just disagreeing. She's explaining that the defendant is trying to skip steps in a system that does not allow shortcuts. And now here's something to think about. If you don't understand when to make an argument, can you really make that argument effectively at all? Because right now, the defendant is not just arguing against the case. He's arguing against the structure of the legal process itself.
I was told this was a probable cause hearing,
This is a probable cause hearing.
so I don't understand what you're saying.
I know you don't understand.
That You're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was
You weren't able to do what?
provide my exhibits
To whom?
to the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have more tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not this time.
All right. So how would you like to proceed next on this?
I'm entering a plea of demurrer.
Okay, you've already done that.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer.
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept as to what they mean.
We're now several minutes deeper, and the tone has clearly shifted. This is no longer just correction, it's confrontation. The judge calls it out directly. The defendant is using legal terminology without understanding it. And in a courtroom, that's a serious problem. because legal language is precise. Words like demur and standing mute are not interchangeable. They carry specific procedural meanings. Using them incorrectly doesn't just weaken your argument, it signals to the court that you lack legal competency. And once that perception is established, every future statement is viewed through that lens. Now notice the escalation. The judge becomes firmer, more direct. That's not emotion, it's control. The courtroom cannot function if one party is misusing the process. And here's the turning point. The defendant continues to push back instead of recalibrating. So now the situation evolves from misunderstanding into resistance. And that raises a critical question. At this stage, is the defendant still trying to defend himself, or is he unknowingly working against his own case?
Demure and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not,
Don't need to.
they are not,
I'm not here.
they are virtually the same thing. So where do you wish to proceed now?
As I stated, my
Do
motion,
you wish this set for preliminary examination? Your motions have been
I
denied.
wish for the prosecution to provide the evidence that any of this needs
You
to.
don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery should be
discovery?
provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery,
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Another 2-minute progression, and now we hit something procedural and very important: discovery. Discovery is the process where the defendant gets access to the evidence against him: police reports, videos, documentation. This is foundational to building any defense. And here's the irony. Despite everything else going wrong, this is one area where the defendant actually needs to cooperate fully. But even here, notice how the interaction unfolds. The judge has to repeatedly clarify what he's asking for. There's confusion, hesitation, and a lack of direct communication. And that's dangerous, because discovery is not optional strategy, it's essential. Without it, you're defending yourself blind. The court steps in, ensures the materials will be provided, and sets a timeline. This is the system working correctly. But the bigger picture remains. Even when the process is helping him, the defendant struggles to align with it. So ask yourself, if you can't clearly request the evidence you need, how do you plan to challenge it later?
Do we have copies of discovery available that can be provided to this defendant?
No, Your Honor, I know that the PD was representing this individual. I don't have copies right now.
I got you. Okay. Mansour, are there copies of the police report as well as other discovery that's in the hands of the public defender's office?
I do see traffic stops and discovery videos onto our program.
All right.
Documents.
All right. Those need to be gotten to the defendant.
Yes, sir.
How soon can those be gotten to the defendant?
I can get those in hopefully by tomorrow around.
You have an address for him to send those to him?
Yes, I do. I can confirm it with him too.
All right. What do you have as the address? Do you have an address on, is it Share?
I do, Your Honor.
Okay.
11410.
Okay, gotcha. All right, you'll make sure that that is sent to him.
I will.
you also have an email address so that all things can be emailed to him also?
I do, Your Honor.
All right. Very good. Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threatened arrest or coercion of you, saying that you would help put out a bench warrant for my arrest. The subject matter in regards to the name as well as the vessel that was used is again under it was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly.
We move forward again, and the defendant attempts another complex argument, this time invoking constitutional clauses and contract law. On the surface, it sounds sophisticated, but in context, it's misplaced. He's trying to argue that the court lacks jurisdiction based on trust structures and constitutional protections. The problem? Criminal jurisdiction doesn't work that way. Courts derive authority from law and location, not from whether someone claims association with a trust or contract framework. And the judge recognizes this immediately. She cuts through the argument and instructs him to put it in writing, because from her perspective, it's incorrect. Now here's the deeper issue. The defendant is not adapting. He's repeating the same style of argument, complex language, weak legal foundation. And courts don't reward repetition of flawed reasoning. They shut it down. So at this point, the pattern is locked in. Assertion to correction to resistance to denial. And unless something changes, the outcome becomes increasingly predictable.
And the trust is properly functioning at this time. So with that.
All right, so here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong, because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So that would be the next step, and I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
Another 2-minute progression, and now we're entering scheduling and procedural control. This is where the court regains full command of the timeline. The defendant asks for more time, tries to question the judge's decision, even hints at bias. That's a risky move. In court, questioning the judge's neutrality without strong legal grounds doesn't help your case. It can damage your credibility. Now look at how the judge responds. Calm, firm, and structured. She explains the timeline, gives him a clear window, and ties everything back to process. No emotion, no deviation. This is how courts maintain authority, through consistency. And here's the critical takeaway. The defendant is still trying to negotiate the system instead of operating within it. But courts don't negotiate procedure. They enforce it. So now ask this. When someone starts blaming bias instead of adjusting their strategy, is that a defense tactic or a sign they're losing control of the situation? Because at this point, the judge is moving the case forward. The defendant is still trying to push sideways.
So I'll adjourn the probable cause conference in this case. April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable.
setting the date
So,
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PC, to a preliminary examination.
just for the record, I put it on the record that I object, but under threat, duress, or coercion. Again,
Your objection is noted.
right, and under threat and duress and coercion, I'll be here. I am Tariq Smart Tariq Day, the executor of the Tariq Smart Tariq Day Living Trust and the registered owner of the Tariq Smart Tariq Day Ex Relatione Kingdom Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the 3rd degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
2 minutes later, and the judge resets the entire foundation of the case again. Why? Because this is required. Every time a defendant represents themselves, the court must ensure they fully understand the charges and consequences. And notice something important. The defendant responds with, "I comprehend," but when the judge explains the complexity of legal rules, he suddenly says, "I do not." That's a major contradiction. On one hand, he claims to understand the stakes. On the other, he admits he doesn't understand the rules that govern the case. And that's exactly the danger the judge warned about earlier. Because understanding the charge is one thing. Navigating the system that decides your fate, that's something else entirely. Now here's the turning pressure point. If you admit you don't understand the rules, how can you effectively defend yourself under those rules? This is where the court starts evaluating not just what he says, but whether he's capable of proceeding at all.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter, and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant, indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role. How religion does not play a role.
Religion does not play a role in what I do or what this court does.
We're now several minutes deeper, and the defendant introduces another angle, religion. He argues that following statutory law conflicts with his beliefs, but the judge immediately shuts that down, and legally, she's correct. Court proceedings are governed by statutory and procedural law, not personal belief systems. Religion can be protected in many areas, but it does not override courtroom rules in a criminal case. Now watch the dynamic closely. The defendant keeps shifting frameworks, trust law, constitutional claims, now religion, but the court remains fixed, because courts don't move between belief systems. They operate within one structure, law, and this is where things escalate. The more the defendant resists that structure, the more the court has to assert control. So the real question becomes, is he presenting a defense or avoiding the framework required to actually defend himself? Because at this stage, the gap between his arguments and the court's expectations is no longer small, it's fundamental.
There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No, sir, what you're about to state is incorrect.
Well,
if you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
Well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules. You are subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Another 2-minute gap, and now we reach one of the most serious moments in the entire proceeding, a competency evaluation. This is not punishment. This is a legal safeguard. When a judge believes a defendant may not fully understand the proceedings, they are required to pause the case and evaluate competency. This ensures the defendant's rights are protected. But let's be clear, this is a major shift. Up until now, the issue was legal misunderstanding. Now, the court is questioning whether the defendant is capable of participating in the trial at all. And notice why this happens. Repeated confusion, inconsistent answers, failure to grasp basic courtroom rules. From the judge's perspective, continuing without evaluation could violate the defendant's rights, so she steps in and orders it. Now consider this. Do you think this situation reached this point because of strategy, or because the court genuinely believes something isn't adding up? Because once competency enters the picture, the entire case timeline changes.
Well, I would agree to a competency if the prosecution as well as the court and the officers agree to take a competency.
That's not the way it works. You don't get to make the rules. I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this.
Yes, sir.
Because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
yes, sir.
Are you going to cooperate and attend that interview?
Under threat and duress and coercion, yes.
Pardon?
Under threat, duress, and coercion, yes.
No. Not how it works. I'm asking you, are you voluntarily going to cooperate?
I say yes. I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
2 minutes later, and now the focus shifts to compliance. The judge is no longer debating arguments. She's ensuring the defendant will follow through with the competency process. And this is critical, because once a competency evaluation is ordered, cooperation becomes essential. Refusal can lead to further legal consequences, including detention for evaluation. Now watch the exchange. The defendant keeps framing his responses around coercion, under threat. But the judge redirects him. This isn't about threats. It's about procedure. And again, we see the same pattern. The defendant interprets actions as pressure. The court defines them as process. And in legal settings, the court's definition is the one that matters. So here's the key point. At this stage, aim of the case is no longer about proving innocence or guilt. It's about determining whether the defendant can even stand trial. That's how far the situation has shifted.
Anything from the people?
Would the court ask the people to prepare the order for the competency?
Yes, please prepare the order for the competency if you would, sir.
And the address for,
The defendant,
I see on the complaint is 1410 Share Avenue, apartment 1-3.
is that your address, sir?
Excuse me? That's correct.
All right, very good.
Right, so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry, can I get that date again, please, sir? I can put it in my calendar.
July 25th, you were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I
the
did.
court.
I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it, I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before?
Well, as I stated at the last hearing,
No, don't go through what you
a week.
stated at the last hearing.
Well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. Young man, you're gonna
That's
figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Day, who is present via Zoom. Sir, can you please unmute and state your name for the record?
Tariq Day.
Thank you, Your Honor. I do have a green form. I neglected to turn in prior to the docket. However, this is the day and time set for PCC. To my understanding, Mr. Day was referred for competency. There was a failure to appear back in October at his competency review hearing. We do not yet have a report from the Forensic Center. I'd respect this question adjournment.
Is this set for competency?
Don't have it marked.
It should be a competency hearing, and we don't have a new report.
Our office has not yet received one, Your Honor, unless the court is in receipt of one.
Well, there was the original one from August.
Yes, and we have no further evidence.
There's no further one.
Am I able to ask a question?
If you, well,
Mr. Day, you can email me or call me and we can discuss any questions you have.
Okay.
We can talk again.
I'll set a competency review hearing.
January 2nd.
I'll set this for January 2nd, 2025, 9 a.m. If
It's
we
just real- it's a
receive
small question.
something, if we receive something prior to then, we'll move the date up. Okay? Bond will continue.
Final stage, and the judge makes the courtroom hierarchy unmistakably clear. Procedure, deadlines, filings, these are not flexible. The defendant attempted to submit a motion late, and the court rejects it based on timing. This is how the legal system maintains order. Rules are not suggestions, they are enforced. And now, with competency evaluation in place, even that motion becomes irrelevant until the defendant is deemed competent. So let's step back and look at the full picture. A defendant chose to represent himself in a felony case. He relied on arguments that the court does not recognize. He struggled with procedure, terminology, and timing, and ultimately the court intervened, not to punish, but to evaluate his ability to proceed. Ours, this case, is a clear example of one core reality. Confidence without legal understanding is not a defense, it's a liability. And now the case pauses, not because it's resolved, but because the court must first answer a more fundamental question. Can this defendant even stand trial? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.